Both the chief executive officer and chief legal officer of Ripple published separate statements to clarify the decision made by the California court in the class action lawsuit that was filed against Ripple. The California court dismissed all class action lawsuits filed against the blockchain company presided over by Judge Phyllis Hamilton on June 21. The remarks were issued in response to this decision to correct the misunderstandings circulating around the XRP class action lawsuit. The firm's executives issued the following. Rumors regarding Ripple's case are clarified by Brad Garlinghouse. On June 21, Ripple's chief executive officer, Brad Garlinghouse, appeared on X to provide clarification regarding the rumors that surrounded the procedural victory in the courts of California. Within his statement, he admitted that the headlines that were used to describe the ruling of the court were both misleading and erroneous. It was a significant victory for them, according to him, that the class action claims were dismissed. In addition, he stated that the ruling did not change the fact that XRP is not a security, as the New York courts had already determined on multiple occasions. The decision made in California dismissed all 4 allegations that Ripple had violated any federal securities laws by launching the XRP cryptocurrency without first registering it as a security with the United States Securities and Exchange Commission issuer. Garlinghouse further emphasized that the state law lawsuit is now slated for trial, where a jury will decide whether or not the CEO deceived investors who were unaware of the situation during a televised discussion on the Business News Network. Even though XRP is not a security, Judge Hamilton stated that it might still be regarded as a security if it were to be offered to investors who were not institutional investors. Another article to read is, again, Ripple mislead investors. The claims made by the CEO regarding XRP are the subject of a lawsuit filed in California. The charges that Garlinghouse made remarks that were false in 2017 were also addressed by him. He stated, "I stand by what I said and look forward to shedding light on this issue during the hearing." Garlinghouse said in his statement that the claimant in the ongoing lawsuit did not purchase the XRP coin directly from Ripple. This information was included in the statement. He couldn't ascertain or not. The plaintiff had heard the statement in the interview before his trade. He stated that the plaintiff only held a couple hundred of the tokens. Using the word trolls, Garlinghouse referred to the claim as another attempt by trolls to take advantage of the loopholes in the United States justice system and distort disclosures to obtain the hundreds of millions of dollars in class action suit settlements. Stuart Alderoty discusses the decision made by the court. Stuart Alderoty, the chief legal officer, echoed the thoughts expressed by the chief executive officer by elaborating on the fact that the California court rejected all charges that Ripple had violated federal securities legislation. In a ruling that was handed out on Friday, the New York court's finding was affirmed, which stated that XRP is not a security. Additionally, Alderoty commented on the state law claim that was filed in 2017 regarding charges of misrepresentation. He mentioned that the plaintiff was unable to prove his case as a result of the plaintiff's inability to provide evidence that he purchased the tokens after listening to the statement from 2017. He maintained that the plaintiff had suffered a loss of money. In his statement, Alderoty highlighted his excitement over the individual state law claim, noting that they were eagerly anticipating the phase of the trial that involved cross-examination. Despite Ripple's recent victory in court, the question of whether or not XRP should be classified as a security remains unanswered. XRP's future could be drastically altered by the possibility of an appeal to the SEC. In the wake of the CNF update, Fred Rispoli voiced his concerns about regulatory inconsistencies over the legal status of XRP. He suggested that the cryptocurrency might be regarded as a security in the state of California, but not in the state of New York. The argument of whether or not XRP should be considered a security has not been resolved, even though Judge Phyllis Hamilton dismissed various claims against Ripple in the Zakhanov litigation. These claims included charges of violations of securities legislation. On the other hand, a trial will be held on statements that are misleading about the offering or sale of securities by the laws of the state of California. This assertion is based on a statement that was made by Ripple CEO Brad Garlinghouse in 2017, in which he stated, regarding the proportion of my balance sheet that is comprised of XRP, I am long, and I am very, very long XRP. To be honest, I am not too long on some of the other digital assets, since it is not entirely clear to me what the true utility of these assets is or what problem they are trying to solve. If you are addressing a genuine issue, and if it is a problem that can be scaled up then I believe you have a significant possibility to continue expanding that. It is evident that we have been extremely fortunate, and I continue to hold a very, very, very long position in XRP. There is a term in the industry that is referred to as HODL, which stands for hold. In my opinion, I am a hodler. Opinions of the court and the consequences they have. The charges that Ripple violated United States securities laws were dismissed by judges in the United States, which is in contrast to a verdict in New York that found Ripple to violate the laws. Judge Annalisa Torres issued a ruling in July 2023 stating that Ripple had broken the rules governing securities in the United States by offering XRP to institutional investors. Ripple and the SEC are currently waiting for a decision from the court regarding the penalty that Ripple is required to pay. The potential appeal of the SEC and its impact on the market, this was mentioned in the court order that Judge Phyllis Hamilton issued, and it was about the SEC and the finding regarding the programmatic sales of XRP. The SEC may find grounds to appeal the decision regarding the programmatic sales if Ripple is unsuccessful in the lawsuit addressing the third prong of the Howey test. Another decision that Judge Torres made in July 2023 was that programmatic sales of XRP do not meet the requirements of the Howey test. Ripple Labs and the United States Securities and Exchange Commission are now engaged in a debate on whether or not XRP should be classified as a security. This disagreement is likely to have repercussions for the whole industry. The matter has been going on for a considerable amount of time, and it is currently in the preliminary stage of the trial. Are you having problems with the SEC? As was previously reported by Crypto Potato, David Hirsch, who is serving as the chief of the crypto asset and cyber unit for the commission, recently resigned from his position. Hirsch announced his departure. He had worked with the SEC for more than 9 years during his career. In addition, he refuted the allegations that he would be working for the cryptocurrency effort known as Pump Fund, stating that he will be devoting some time to his family before beginning the next phase of his professional life. This took place a few days after the Securities and Exchange Commission reduced the huge penalty it had requested from $2 billion to $102.06 million. This was done in response to the demands made by Ripple's legal team, which requested that the penalty be reduced to a maximum of $10 million. As stated by the SEC, Ripple does not proceed with the comparison of the penalty for the Terraform settlement to the gross profit that was made from the violated behavior. That ratio is much greater than the average, coming in at $11.72 million, 587 cents billion. As a result of applying it to the gross earnings of $876.03 million, the SEC is requesting that the court disgorge the money, which results in a penalty that is significantly higher, $102.06 million, than the $10 million maximum that Ripple insists on. Fights on a number of different fronts. Ripple's several ongoing problems are not over with the resolution of the case against the SEC.